Thank you, Mr. Chair. I seek leave to move opposition amendments 1 and 2 on sheet C 2015-162 capital B in globo.
Is leave granted? Leave is granted.
I move opposition amendments numbers 1 and 2 as by leave permitted to be moved in globo. Opposition amendment number 2 removes much of Schedule 1.8 from the bill. It keeps square brackets 1 in because that makes a genuine clarification that the term offence in the Criminal Procedure Act means not only a statutory offence but also a common law offence. And that's a genuine clarification, we think, not a substantive change to the law. So we retain that. But we remove all the other changes which, as we perceive it, extends the prosecutorial function to a wider range of bodies than is currently permitted, and to a wider range of persons in all of the bodies determined to be public bodies and whose employees are properly understood as public officers within the terms of the meaning of the Criminal Procedure Act. And I refer in particular to those bodies and persons employed in them in Clause 101 of the Criminal Procedure Regulation 2010, which puts flesh on the bone of the bare definition in the authorising statute. So opposition amendment number 2 takes all of those things out for which we think no proper public case has been made out. Opposition amendment number 1 inserts some provisions which are, by and large, limited to the institution of the Independent Commission Against Corruption. In this provision, we seek to clarify the existing position for ICAC at common law. At the moment, as the attorney in the other place indicated, and as I think I reflected in my second reading contribution, in one matter there was some dispute about whether an officer of the ICAC could, at common law, lay an information in relation to an offence. This provision makes it clear that an officer of the Independent Commission Against Corruption does not have the power to commence proceedings for an offence unless the Director of Public Prosecutions has advised the ICAC in writing that the proceedings may be commenced by an officer. It also provides that the DPP may liaise with the ICAC for that purpose about whether or not the DPP should exercise that function, but makes clear that the independence and the discretion that resides in the DPP is maintained in this regard. It's not merely a tick and flick exercise. The DPP has a discretion which may be given or withheld. So that's what it does. And in subsection 4 it defines clearly what is meant, for the purposes of this amendment, by an officer of the ICAC to mean the Commissioner, Assistant Commissioner, or an officer of the ICAC. Now, this provision meets, I guess, the concerns of the government to genuinely clarify what the position is for the Independent Commission Against Corruption presently, and to do so in a statutory form. But equally, and that is not something that the opposition would otherwise necessarily have supported, because we have steadfastly maintained that for serious criminal matters there should be a separation between the investigative function and the prosecutorial function. However, this provision meets those concerns by making it clear that whatever function ICAC has in this space is completely submitted to the discretion of the Director of the Public Prosecutions about whether any prosecution is able to be brought by an officer of the ICAC. So the proper superintendence of criminal prosecutions in this state by the Office of the Director of Public Prosecutions is maintained, and for the first time in a statutory form, whatever functions the ICAC may have in this space is brought under that umbrella. Now, I understand at present that these matters are currently dealt with by way of a memorandum of understanding between the Office of the Director of Public Prosecutions and the Independent Commission Against Corruption. I'm not familiar with the terms of that memorandum. I'm not sure that it's a public document. But whatever the case, we think that's not a satisfactory state of play. We think these things should be brought into the light of day and put into a proper statutory form, with the DPP clearly as the gatekeeper and guardian of the public interest as to whether or not such prosecutions should be instituted. So that is the new proposed Section 14 capital A, subsections 1, 2 and 4. And it's quite clear that the intention of the opposition in putting these forward is that it's a matter for the discretion of the DPP as to whether a prosecution proposed by the ICAC should be or is able to be commenced. It's up to the DPP. It's a matter for the DPP's discretion to be given or not given based on the merits of the matter and any guidelines that the DPP may promulgate for these purposes. Subsection 3 does something a little different. It clarifies, or indeed makes abundantly clear, that the Commissioner of the Police Integrity Commission, an Assistant Commissioner of that body, or any officer of that body do not have the power to commence proceedings for an offence. And of course, because of the new definition of the term offence, that would cover any statutory as well as any common law offence. So to the extent that at common law an officer of the PIC may presently, under the criminal procedure legislation, be able to lay on information privately and may, in theory, have access to the court attendance notice provisions of the Criminal Procedure Act, this provision closes the door firmly on that possibility, puts that beyond any shadow of doubt. And so we think that these amendments taken together thoroughly address the concerns that the opposition has articulated in the debate on this bill and, of course, in public discourse around the bill in its current form, meets those concerns squarely and comprehensively, and would render the legislation in such a form that it should pass the House without difficulty. While it may be that the officers of ICAC do have these common law powers, it's important they be codified and made completely subordinate to the discretion of the Director of Public Prosecutions. I note in his second reading contribution, Mr David Shoebridge referred to an article by the former DPP, Mr Cowdery, and by and large the opposition does agree with those concerns that there should be the proper separation of investigatory and prosecution functions at the most senior levels. We do recognise, however, that at the lower levels of the criminal justice system, police still do investigate and bring lower level charges. In the case of the ICAC, we do think, and we are conscious also of the miscellaneous discussion in the recent Gleeson-McClintock review, which merely said that the Parliament should give some thought to this matter. I don't think this embraces those discussions fully. This is limited to what may or may not be the ICAC's power or powers of any of its officers at common law. It codifies them and makes them subordinate to the discretion of the DPP. I think that is an appropriate balancing of the different public interests that are at play here. The interests that, in the appropriate case, ICAC should be able to bring these matters to the courts, but only if the DPP, in the exercise of his independent discretion, advises that such a proceeding may be commenced. No doubt we will have some debate about what may means, but I will save my comments on that for when we cross that bridge. But I urge all honourable members to give favourable consideration to these amendments. Thank you, Mr Chairman.
Mr Chairman.